Hi, I'm Viv Coles and I'm a senior caseworker in the civil billing team of the LAA based in Cardiff. I've been with the LAA for just over 12 years now, having worked in the billing team for most of that time. I process most aspects of the work we do, so all the different types of bills such as fixed fees, escape fixed fees, court and voluntary assessed claims and hourly rates. I also deal with cost appeals and billing and case inquiries, and I'm also involved quite a lot of the time in training existing and new colleagues. So that's a little bit about me. So to start today's webinar, we thought we'd do a little introduction to the Family Advocacy Scheme. So that's on slide 6 of your slide pack. The Family Advocacy Scheme, or FAS as we generally call it, we thought we'd just go through a few details of the scheme, taking into account that some joining us today may be new to legal aid work, so you might not be so familiar with the scheme. So the FAS scheme was introduced in May 2011 and replaced the Family Graduated Fee Scheme. The scheme was introduced for all family cases where proceedings fall under these categories. So we have care and supervision, private law children, domestic abuse, finance and other public law. Moving on to slide 7 in your pack. So the basis of the scheme is to remunerate preparation for a hearing, advocacy and travel time under a fixed fee for each activity. And by activity, we mean a hearing or advocates meeting. And in the case of counsel only, also there will be a conference fee and an opinion fee. The fees under the FAS scheme differ depending on which of the above proceedings applies, but also which level of court the activity relates to. So basically, there's different fees for lay bench, so that's formerly the Family Proceedings Court, district or circuit judge, formerly county court, or the High Court, including S9 panel judges. In addition, bolt-on payments and court bundle payments can be claimed where applicable. And that's also exceptional travel bolt-ons, which is where your journey to the court is over 25 miles each way. Other bolt-ons that can be claimed, and they're 25% of the fee you're claiming. So we have expert witnesses being significantly challenged at a hearing, clients have difficulty understanding instructions, or client is actually facing allegations of serious harm. One thing to note is attending behind counsel at hearings isn't considered to be advocacy, so that will still be remunerated at hourly rates, and counsel will claim that under FAS. So moving on to slide 8 in your pack. So we often have S9 panel judges sitting as High Court judges, as I mentioned earlier, at the Family Court. And in this instance, fees should be claimed at High Court rates. Each court order must state that the judge is sitting as an S9 judge to be able to claim it at the High Court FAS fee. So, okay, so that was just a little introduction. I'm now going to hand you over to Kat for the next section.
Hi, so my name's Kat. I work in the finance team for civil billing in Leeds as a senior caseworker. As well as processing bills, I'm also involved in our internal quality control process, as well as training and mentoring. I am currently training a team of caseworkers on voluntary assessed bills. So that's a little bit about myself. Hi, my name's Kat. I work in the finance team for civil billing in Leeds as a senior caseworker. As well as processing bills, I am also involved in our internal quality control process, as well as training and mentoring. I'm currently training a team of caseworkers on voluntary assessed bills, and that's a little bit about myself. So in this section, I'll be covering FAS in general, and I'm going to start by discussing single fees per hearing. So under FAS, only one fee per hearing may be claimed. Where different matters concerning your client are dealt with together by the court, Whether they're listed together or listed consecutively, they should be treated as one hearing for the purposes of FAS. So, for example, a hearing for a child arrangement order and a hearing for a non-molestation order listed together should be claimed as one single fee. You can choose whether you claim the fee applicable to non-molestation or private law children. So if the whole hearing was 2 hours, 25 minutes, which means hearing unit 2 applies, you can choose to claim the hearing unit 2 for non-molestation, which is £203.76, or the private law children fee for hearing unit 2, which would be £172.40. Where multiple parties are represented by one advocate and the applications are dealt with together by the court, only one fee is payable for the hearing. I'm going to move on to slide 11 in your packs. So proceedings covered inside and out of FAS. Where a hearing covers significant work under both FAS and excluded work, it will be treated as excluded and paid at hourly rates. Evidence should be provided to confirm the excluded work was not a significant part of the hearing. Where you have two proceedings, where one falls within the fixed fee scheme and FAS, and the other is excluded proceedings, the lead proceedings should be billed as an interim bill, and then a merits inquiry should be submitted on CCMS requesting the proceedings you haven't billed to be changed to the lead proceedings, and then you can submit your final bill. Related proceedings are proceedings which are heard together with public law children cases or proceedings in which an order is being sought as an alternative to an order in such proceedings. Where there are related proceedings, the cost of this work will be claimed within the standard fee. In terms of FAS, this should be remunerated under care rates. Moving on to slide 12 in your packs. What is included in the fee? So the advocacy fees cover work that was necessary as a result of the advocate attending court. It doesn't include the work of the solicitor conducting the case or work required in getting to the point where advocacy is required. As an example, emergency protection order proceedings, where you're instructed to represent the client at court that day and you have to prepare for the hearing, but you're not reconsidering documents in preparation, you're looking at them for the first time. This is work that would be considered to be getting to the point where advocacy is required, so this would be payable at hourly rates and wouldn't form part of the FAS fee. Examples of work that would fall under the advocacy fee for FAS would be things like any time spent to reconsider the documents for the purpose of the hearing, drafting the attendance note of a specific hearing, or time spent preparing and agreeing a draft order. Work that doesn't fall under the advocacy fees for FAS would be any time spent on the consideration or drafting of documents. For example, time spent considering an order received from the court following a hearing and communicating its content with the client should be claimed under the applicable representation fee. Moving on to slide 13. So solicitor agents and independent solicitor advocates. So solicitor agents, costs should be claimed at an hourly rate or under the fixed fee rather than as a disbursement. Now, these can be claimed direct under FAS if the advocate is registered with the LAA. Independent solicitor advocates can continue to be paid as a solicitor agent, or they can register as an independent solicitor advocate in the same way as counsel. To do this, they must be registered with our provider records department as an independent advocate. Moving on to excluded proceedings under FAS. So there are certain proceedings which are excluded from FAS, and these are listed on slides 14 and 15. I won't go through them all, however, just to pick one as an example, appeals against the final order. Appeals against a final order, whether to the Supreme Court, Court of Appeal, Divisional Court, they are excluded from the scheme. However, any application to court of first instance for permission to appeal and any advice on the merits of an appeal against a final order are covered. Interim appeals do remain within the scheme. Adoption proceedings, so that's slide 16 in your packs. Where parents or other parties are being represented, the work will fall within the FAS. If it is the child being represented, this will fall outside of FAS, because separate representation of a child only falls within FAS if the representation is a specified proceeding under Section 41 of the Children's Act 1989.
Okay, thank you, Kat. So we're moving on to the next section now, that is on slide 18 of your pack, and this is calculating the fee. So calculating the applicable fee, and this is generally calculated in one of two ways. Firstly, we have interim hearings. So that's a hearing where it isn't expected to be a contested and effective hearing to conclude matters. So the fee here will be calculated based on the length of the hearing. There are two hearing units. Hearing Unit 1, which is where the hearing was for an hour or less, and then Hearing Unit 2 for over an hour. With Hearing Unit 2, the fee will be calculated in multiples of Hearing Unit 2 at 2.5 hour increments. And there's an example in that in the slide you'll see there. So the hearing is generally measured from the time it is listed to start, and that's going to be including pre-hearing discussions directed by the court, to the time the hearing concludes, and that's disregarding any lunch break or overnight adjournments. So moving on to slide 19 in your pack. Final hearings then. So this is where the hearing is expected to be contested and effective as the final hearing concluding matters. So for the final hearing, the fee is payable per day, regardless of how long or indeed how short it was. So whether it was 10 minutes or it was 8 hours long, it's one final hearing payable per day. It will, however, exclude any day set down solely for the court to hand down judgment where no advocacy is expected. Advocates' meetings cannot be claimed on the same day as a final hearing. I also thought it would be worth mentioning that in private law proceedings, regardless of the fact the client may be the parent in the proceedings, if they are under the age of 18 when the certificate is granted, so not that they become 18 during the course of the certificate, it's actually at the date, when the certificate is granted. If they're not 18 on that date, they will be considered as a child. So that would be considered a separate representation of a child and should be remunerated at hourly rates only. And just a top tip on the slides there. So to help ensure your claim the correct fee, please use the civil claims rates calculator. And there's a link on the slides there for you. Moving on to slide 20 now then. So paper hearings and cancelled hearings. So we just thought it'd be useful to cover a little bit about these two types of hearings. So where the court considers the matter on paper, so based on statements rather than calling an actual hearing, a hearing unit 1 will be payable. We would ask you to ensure that it's clear from the court order that the matter was heard on paper, or that the court considered the statements in the application and that no parties were present. Okay, and cancelled hearings then. So where a hearing is cancelled, the preparatory costs should be included within the fixed fee or hourly rate claim. And also if the hearing is cancelled after you've actually travelled to court, so basically you travel to court, you're expecting to go into a hearing and for whatever reason it had to be cancelled, this again should be included with the fixed fee or if it escapes the hourly rate claim. And that obviously should be claimed at the applicable travel rate. So moving on to slide 21 now, we have multi-day hearings. When an interim hearing runs over multiple days, the fee is calculated based on the cumulative time of the hearing, excluding any adjournments for lunch or overnight adjournments. It can apply to non-consecutive days. It doesn't have to be, next day. It could be a couple of days in between. So if the court considers both days to be part of the same hearing, then the same rules would apply. And the relevant guidance can be found on 14.6, Appendix 2 of the Cost Assessment Guidance 2018. And our top tip there is to clarify the details in your bill narrative if the court order doesn't make the position clear. It doesn't always, so just have a look what it says, and if it's not very clear, please can you obviously try and clarify that either in the bill narrative or the default document request. So a little bit further on multi-day interim hearings then. So on slide 22, so in terms of claiming multi-day hearings on CCMS, you should claim it as a single line. CCMS will allow hearings of up to 15 hours to be entered, but should the total times exceed this, then please add a second line for the remaining number of hearing units. Sometimes on interim hearings, different advocates may attend on different days. So in that scenario, we will pay the final advocate for the whole hearing, and then it'll be up to that advocate how the fee is to be apportioned. A little bit more straightforward with final hearings, as advocates can just claim per day for the ones that they've attended. So finally on that section, top tip, in the Civil Claims Rates Calculator, there is a tab called FAS Multi-Day Unit Calculator, and it's a really useful tool to calculate the correct rate if you have a multi-day hearing. You can actually use it just to calculate a single day, but you can use it for both, and it is pretty useful. Okay, that's the end of that section. I'm going to hand you to Kat now for the next section.
Thank you, Viv. This section is on advocates meetings. So advocates meetings are claimable in public law proceedings only. There is no limit to the number of advocates meetings that can be claimed. However, when 2 or more have already been paid, the court order must be uploaded for any additional advocate meetings claimed. The rate for advocates meeting is determined by the level of judge at the related hearing, which would be the hearing that follows the advocates meeting. The level of judge should be evidenced within your claim. No fees for advocates meetings will be payable in private law cases, and any work undertaken in relation to an advocates meeting should be claimed under the representation fee. In cases where an advocates meeting and a hearing are scheduled for the same day, the proceedings are resolved at the advocates meeting. The advocates meeting fee should be claimed as normal, and any time spent preparing for the hearing should be claimed under the representation fee. If an advocates meeting takes place on the same day as a final hearing or issues resolution hearing and matters are settled, then it cannot be claimed separately from the hearing, as the fee is to cover the entire day at court. And I'll hand back to Viv. Thank you.
Thank you, Kat. Okay, so moving on to slide 27 of your pack now. This section is all about final hearings. So it isn't always clear if a hearing was attended to be an actual final hearing, so we thought this section would be useful to give some clarity. And you'll see we have some links to the various guidance in the slides. So firstly, to be payable as a final hearing, the hearing must be listed as and expected to be the contested final hearing. Where a hearing is listed as a final hearing but is adjourned or postponed before the substantive issues are considered, we consider that to be an interim hearing. Just to clarify that then, so it's probably best to give an example. Where there is a final contested hearing listed with the expectation that the matter will conclude, but an expert, say, hasn't been able to turn up for the hearing, hasn't been able to make it. So the court may decide that a final hearing can't proceed without the expert present. That would be considered to be an interim hearing, even if the hearing is used for some case management. However, if the court decided that they can go ahead and make substantive decisions on some of the issues, potentially hearing from other witnesses before adjourning so that they can hear from that expert witness who wasn't able to attend, then we can actually pay that as a final hearing. There are occasions where two or more aspects are heard together, one being intended to be a final hearing and the other or others not. So they're not expected to be effective as a final hearing. So, for example, you may have the return or final hearing on a non-molestation matter, but children's matters are heard, but not as a final hearing, and further hearings are listed for those children's matters. So in that instance, you would be able to claim the hearing as a final for the non-molestation at the relevant fee for domestic abuse. Okay, so moving on to slide 28 in your pack. So in the next few slides, we'll look at the other types of hearing where potentially a final hearing fee can be claimed. So firstly, we have finding of fact hearings, and these are claimable at final hearing rates, subject to the hearing being effective. And this applies to both private law and public law proceedings. In private law, a final hearing court bundle can be claimed for the finding of fact and the final hearing fee for the actual final hearing subsequent to that. In public law, that's not the case. The final hearing is considered to be a continuation of the finding of fact, and only one final hearing fee may be claimed. So moving on to slide 29 in your pack, issues resolution hearings. So in public law proceedings, if a case is concluded at an issues resolution and so doesn't proceed any further, the hearing should be claimed at final hearing rates. One thing to note with issues resolution hearings is that if you're representing a number of children, so usually siblings, so it's joint representation of children, if the court makes a final order for one child but lists further hearings for other children, an interim fee would be applicable for the IRH because the case is not actually concluded. Okay, so moving on to slide 30 in your packs. So dispute resolution appointments. Potentially they can be claimed as a final hearing, but they do need to meet the usual FAS criteria for a final hearing. That is defined in 7.127 of the Standard Civil Contract 2024. So it must have been listed with the intention that a final determination would be made and be expected to be both contested and effective. The important thing to note here is that the certificate must cover final hearing, and you would need to submit an amendment prior to attending the hearing if you aren't covered. So the next type of hearing is an early neutral evaluation hearings. I haven't personally seen these very much, but courts are tabling these in lieu of a final hearing or an IRH with a view to resolving the matter without recourse to a subsequent final hearing. In these circumstances, they should be treated as final hearings. In all other cases, an interim hearing fee would be more appropriate. So moving on to slide 31 in your pack. Early final hearings. So we're seeing this increasingly used to describe a hearing in court orders. It's usually referred to in conjunction with an issues resolution hearing. That's sort of basically how we treat it. We just treat it as an issues resolution hearing. But if the hearing is actually listed as an early final hearing on its own, we would have to really consider whether or not it meets the definition of a final hearing. In reality, it's most likely to be an interim hearing. But if you do actually think it is an actual final hearing, then what we'd ask you to do is provide some justification, which again you can add it to your bill narrative or note it in the default document request. Slide 32 in your packs. So this is domestic abuse return hearings. Return hearing in domestic abuse proceedings where the respondent has been given notice are generally payable as a final hearing, even if the respondent is expected to attend but fails to appear, which we know happens quite a lot. But yeah, that can be claimed as a final hearing. If, however, the client withdraws their application in advance or the respondent confirms in advance that they'll not be contesting the application, then that wouldn't be considered a final hearing and it should be claimed at interim rates. And finally, in this section, consent orders. So a hearing listed with a view to the issues being dealt with under a consent order or which otherwise isn't expected to be effective or contested is not a final hearing. Other hearings such as directions hearings or other forms of interim hearing or a case management hearing that concludes proceedings is not a final hearing for the purpose of FAS. And now we'll move on to the next section and I'll hand you to Kat.
Thank you, Viv. In this section, we'll be looking at supporting documents and supporting evidence. So for FAS, we require court orders to evidence the hearings, and these should include the start and end times of any hearings and details of any adjournment. The court order should also include details of any bolt-on and bundle fees. In cases where the court order does not include these and there is a fee being claimed for these, we would expect further evidence to support these costs, for example, an attendance note. Also, evidence should be provided in support of any travel expenses for public transport over £20. A copy of the ticket or a receipt should be uploaded with the bill. Moving on to slide 35. So the court order is the standard evidence for FAS hearings, and this is the template which shows the information that you must provide. Moving on to slide 36, common issues with supporting evidence. Just going to go through some of the main issues we come across. This isn't all, but these are some of the main ones. So time gaps. If there is any gap between the pre-hearing discussions ending and the hearing starting, or the hearing ending and drafting of the order starting, we would require clarification if any work was done during this time so that we can establish whether or not this should be included in the overall time. Next one, total attendance time. Where the order gives a total attendance time that differs from the specific details of the hearing, start and end times and any adjournments, please provide your attendance note which should confirm the times. This is really necessary where the difference affects the hearing units being claimed. No start and or end time. If any of these details are absent from the court order, please provide your attendance note which should confirm the missing information. And finally, lunch adjournments. If a hearing continues over lunch, which is usually like between 12 p.m. and 2 p.m, there is an expectation that a lunch will have been taken. If the hearing starts or finishes during the hours of 12 p.m. and 2 p.m, it is helpful to indicate that no lunchtime adjournment occurred. And that's my section done, so I'll hand back to Viv. Thank you.
Okay, so moving on to slide 38 in your packs, this is the last section. We just thought it'd be useful to go over some points regarding council FAS billing. So council are generally allocated their own cost limitation on CCMS. The final cost paid to council must match their allocation, and the cost should be the net cost, so not including VAT. And that's purely because VAT isn't included in the cost limit on a certificate. But if you did include it, it'll get factored into the cost limit. Can be potentially an issue if your costs that you're claiming are actually quite near to the cost limit, because it's factored in that VAT amount that doesn't need to be there. So for FAS cases where you're submitting the final bill, the LAA require the balance of the costs remaining to council to be zero. Basically, so we know there won't be any further claims from council. If council's claim is less than the amount they have been allocated, then we would have to reject your claim. So it is always worth checking this. And you can check the amounts allocated and paid to council via the case cost detail screen, which is shown in the table in the slide there for you. So moving on to slide 39 then. So you can also check the remaining costs allocated to council prior to submitting the claim via the case statement of account screen, which again is in the slide. The total council cost ceiling line shows the full amount allocated to council, and where the council has submitted a bill that has not yet been authorised. So that's something that's actually quite useful, especially on hourly rate claims. So you can see that they've actually submitted bill, but it's not showing as paid as yet. So that is quite useful. Particularly with hourly rate claims, as I say, because those solicitor bills and council bills actually have to be processed at the same time. That's our last section in today's webinar.